Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
Hi everyone, I'm Rebecca Strauss with Miller Johnson, here with another episode of Off the Clock. For regular listeners, you know I normally am sitting here chatting with my friend and partner, Sarah Willey. Sarah couldn't be here today, so I decided, instead of being sad by myself in Kalamazoo, to hop in my car, drive up to Grand Rapids, and talk to some of my other friends and colleagues. So today, I'm so lucky that Mary Tabin agreed to chat with us. Hi, Mary.
Good morning. I'm here for the free coffee and, of course, to see your smiling face today.
I'm so excited for you to be here.
So am I. I'm excited about our topic.
I am too, because it is something you do a lot of and are passionate about, and it stresses our clients out. It's a great combination. I really wanted to talk to you about investigations.
Is it weird for me to say that I love investigations? I mean, is that kind of weird?
Well, a little.
Probably not to you, right?
No,
we both love investigations.
I'm someone that loves the Fair Labor Standards Act, so we're just two misfit toys, perhaps, in the same old toy chest. But the word investigation, so you think it's probably weird to say you love it because it sounds intimidating. It sounds like something the police do or the FBI does, right? But when you and I use the word investigation,
yeah, it does sound daunting, does it? It sounds like, right, FBI is going to be knocking on your door, somebody's going to be taking one of those like big metal rods, like breaking down the door on the way in. But investigations really is just a review. It's a review of a dispute that's going on, really when there is more than one side to a story. You receive a complaint and an employee is saying that they were wrong somehow. Either someone was inappropriate to them, or there's a policy or practice that they are not happy with, or just a lot of different fact patterns. And it can be extensive or it can be really quick. So if you have a dispute and there is a documentation that answers the question or answered the dispute, it can be very simple. Or if all employees agree on what happened, and it also, though, can be really extensive if you have a really difficult fact pattern or a long practice or pattern that someone is complaining about. But with all good reviews, though, you want to make sure that you have an impartial reviewer looking at the facts. So when I say impartial, though, what do you think of that? How do you approach investigations?
I think that can be really tough in certain circumstances. So normally these things come to HR first, right? Maybe to a supervisor first,
Yep.
And then to HR. When the HR person charged with investigating, and by the way, I love your use of the word review and said it's so much less intimidating. Why don't we even just start saying that? So when the HR person is charged as part of their job with reviewing the complaint or the issue to find out exactly what happened, and they know either the person making the complaint or the person being accused of some sort of misconduct, that can be very challenging because they may jump to a conclusion, right? We all do that. This is human nature.
Exactly
It doesn't
right.
make you a good person or a bad person. It just makes you a person, right? To think about your lived experiences and how they may influence. So we have to fight against that. Oftentimes, I do think it's possible, but there are examples when the person whose job it is to do the review investigation probably needs to speak up and say, I can't do it because I don't think I can be impartial. And the example that comes to mind most obviously is when there's a hierarchical reporting relationship within an organization and the HR manager is charged with investigating or reviewing a complaint against the CEO or a board member. Or maybe the manager of HR is charged with reviewing a complaint against the VP of HR. In my opinion, that is fraught with difficulties. And even if the HR person can do it, it's going to be second guessed after the fact. So if an HR employee finds themselves in that situation, Mary, what can they do to maintain the impartiality of the investigation?
Yeah, investigations have become so much more difficult in this litigious society that we unfortunately live in, and a lot of employees second guess because somebody is going to be unhappy with the investigation, right? So the person complaining, if they don't get the relief that they think they're entitled to, or the person who's being accused that really believes that they have not done anything wrong, and then they find themselves getting corrective action, somebody is going to be upset. Rarely when you do a review is everybody happy.
So this is not a happy day
yes.
when the need for an investigation comes into HR. Is that what you're trying to say?
Exactly. And although HR, right, HR is not known to be a happy place and they're used to receiving complaints.
Yeah.
Sometimes these investigations where impartiality, even if the HR director can be impartial, those that are looking at it after the fact may think that they are not, just from the very fact that they have known the employees for a certain amount of time. So one, like when you were talking about when there are HR director with a board or an executive, that is a good time to press pause and seek outside counsel and outside assistance on that. And also if the fact pattern is very complex and there's lots of employees that need to be interviewed because there's not a lot of documentation. You know, HR has more to do in a day than just investigations. They have lots to fill their plate. And so timing of an investigation, even if a fact pattern isn't all that complex, if they don't have time to do it, or that has been how they want to deal with employee complaints that get to really where there are issues on protected categories, right? I am being wronged because I'm a female, or I'm pregnant, or I'm a minority, or because of my age. When it deals with more than personality clashes, that is also a good time to bump it up to outside counsel.
Excellent point. So you mentioned that HR folks have other things to do, right? Hello, COVID. No one has time. No one has free time built into their week for investigations, which brings up another point. Investigations really should be done quickly to be done well. We're going to go over a few different aspects of an investigation or a review for when folks are doing it themselves, okay? Because if they're calling us, we'll kind of take it from there. But if they're doing it themselves, it's important to remember that timeliness is critical. From a legal perspective, particularly as you mentioned when there's protected characteristics involved, right? Someone complaining about sexual harassment, racial harassment, etc. Employers have a duty to investigate, a legal duty to look in to see what actually happened, and that response has to be reasonable. And what is reasonable and what is not, this is why we stay in business, because people can argue about those things all day long, but courts have said one thing they will look at is how quickly the employer responded, investigated, and reached conclusions. So this is another reason why it's not a good day in HR when someone comes in with a matter that needs to be investigated, because it really is a sort of thing, in my opinion, that now you have to start working on it today. And a lot of HR folks, right, don't have half their week set aside, right? Like doctors' offices have half their days set aside for sick visits. I don't know of any HR client, right, that has that. So that may be a time to bring in extra help as well, right? Whether it be a law firm or an investigation firm.
That brings up a good point, Rebecca. So how I often get asked, and I'm sure you do too, well, how quick is quick? Do I have to drop everything and get all these 20 witnesses done today? Or, you know, the holidays are coming up, or we have this strategic planning session, or I'm on vacation for a week. You know, all these things that HR departments are thinking through, or I'm understaffed because of COVID. What do you say when they ask how quick is quick?
Yeah, well, this is when they hate their lawyer. But really, it should be priority, and some of it can depend on the seriousness of the allegation. If it's a serious sexual harassment allegation or racial harassment allegation, and the person who's making the complaint is in a work setting with a potential wrongdoer,
Yep.
you're going to look really silly after the fact explaining to a court that you didn't look into it for 2 weeks because you went on vacation, right? Meanwhile,
Yep.
well, that employee is dealing with potentially a very stressful, right, and harmful situation. So what I always like to do in these situations, and frankly in my personal life, is to think about if someone were to second guess this afterwards and want to make me look bad, would this, because that's what a plaintiff would do, right?
Yes,
They're not
you're
going to try to
right.
defend you. They're going to do everything they
You're
can to make you
right.
look bad. Would this look bad? Now, if you started interviews the day after getting a complaint, of course you're not going to look bad. What else could you have done? If you start interviews a month later, now you could start to appear insensitive, right, to the
Yeah.
complaint itself.
Yep.
It may even look like you prejudged the complaint. Back to what we were just talking about, impartiality.
Yep.
They could say, you didn't believe me in the first place, right? That's why you waited so long, because if you had believed me, clearly you wouldn't have waited. So this is kind of like when I feel like the Department of Bad News, and it's not my favorite part of my job to deliver bad news, but my advice generally is, again, depending on the seriousness of what is being alleged, it should usually take priority over other matters. And I then offer to make it a little bit better maybe and talk to the boss, right, myself, and explain why. But there should be some sense of urgency, don't you think?
I do. But what COVID has taught us, though, is sometimes life throws a curveball at you. And so when you are acting really quick and prompt, though, and something happens where you just can't get to everything, a lesson in life that applies beyond just investigation is communicate, communicate, communicate. So you want to
Yes.
communicate to the employee that is complaining. I wanted to give you an update on the review. We take this very seriously, but COVID hit this warehouse, and so we are going to pause our investigation there until we are able to safely conduct the investigations. Or, we need to do X, Y, and Z a little bit differently, and so that may take additional time, but I wanted to keep you updated. So if there is, for whatever reason, a necessary pause in the investigation, we don't want to stick our head in the sand. We don't want to just assume that the person that is either complaining or being accused is okay with how long it takes. Yeah. We want to be able to communicate that. So when that armchair quarterback comes in and second guess the investigation, you have a good documentation trail of why it took an additional month or so.
I think that communication piece, Mary, is so important. And we're not going to, all the mistakes that we've seen clients make, because it's not our job to make people feel bad here today.
Yes.
But if I could pick just one, it would probably be that lack of communication. Effective communication can solve a whole host of problems. Mm-hmm. Nobody likes to be ignored. And do you?
No,
I know.
Right, exactly.
We won't go into it, but we don't know. And we all know I don't either. And when someone has made a complaint, oftentimes it has taken them some emotional strength, right? And it's a burden on them by the time they get to make that complaint. So they are emotionally fraught.
You're right.
The person accused of wrongdoing, if it's that sort of complaint, has a whole host of angst as well.
Yeah.
And the worst thing you can do in a situation like that is leave folks in the dark. And I don't think HR folks intentionally do that, by the way. I just think, for the reasons we just talked about, they had a million other things to do.
Yeah.
This investigation, this issue just landed in their lap. They're trying to reprioritize, reshuffle, and the communication updates to the person who made the complaint and the person being accused, which people forget about,
Yes.
it just slips their mind. And as soon as I say something like that, the reaction almost always is, oh my gosh, of course, yes, I don't know why I didn't do that, right? Why didn't I think of that? And then they go off and do it. But it's so often forgotten. And I think it's important even when it's a quick investigation, but particularly if there's delays, holy cow, right? That can diffuse a whole lot of problems.
I agree. And I think for the reasons why you just mentioned, HR can do a really good job of investigating, but then be short on documentation. And in our world, right, it didn't happen unless it's on a piece of paper, right? Or and a piece of paper that's given to somebody else. Then it's happened. Then we can prove to an EEOC investigator, MDCR investigator, a judge, anyone, an attorney, an employee's attorney, whoever's looking at the investigation to wonder if you've done it impartially and prompt and remedied the issue. Then you can prove that you've done that. So what I often say is, let's put all of HR's good work into actual provable work so that we can prove that you did a good job in the investigation. So not only do you want to interview those folks, but you want to put that in writing. You want to communicate with the person complaining and the person that's being accused, if again that's the type of investigation. And then at the end, you do want to have a report to show what your process was of why you concluded what you did. And then to summarize that to both of the parties that are on both sides of the spectrum there.
I really want to talk about how to do those interviews with witnesses, how to document them, et cetera, because that's a huge area, a black hole, if you will, for a lot of our HR folks. But I want to jump ahead to the end of the investigation for a moment, because you said something that just triggered me.
Okay.
It's such a common question. And here it is. Don't assume anything. The person that made the allegation, right? You just said I need to follow up with them and tell them what the result was. What can I tell them the company did in regards to the person who was accused of wrongdoing, assuming it's that type of investigation? Do I have any duty to the person that may have been disciplined, for instance, to maintain that confidentiality? Or can I tell the person who made the accusation exactly what actions the company did related to that person who was accused? Is that a question you get all the time, too?
It is, and it's a difficult one to answer. So because the employee who's making the complaint oftentimes wants to know everything, wants to know who you've talked to, what you've looked at, and what the remedy has been. Is this person getting fired? I want to see the corrective action that's being placed in their file. They want to know because it's really important to them. Like you said, it takes a lot of courage to make a complaint. If we're talking about good faith complaints, it takes a lot of work up the beginning. There's a lot of issues that employees usually work through before they make the complaint. And so, what I say is they're entitled to some, from a good employee relations standpoint, in and of itself, different than just a legal standpoint. But a good employee relations standpoint is you want to try to have this investigation, which is disruptive in the workplace from the beginning. You want to try to, when it's all said and done, leave the workplace a little bit better. And so that's where communication is the key there. Regarding the employee that is complaining, though, they ought not to get the chapter and verse of what the investigation is. But they should get a summary of what they complained about, a summary that you did look into it, you did conduct interviews if that's appropriate, you did look at various documentations. You don't have to mention who you interviewed and what you looked at, but you can summarize that. And then you can also say that whether you've substantiated their complaint or concerns or whether you did not substantiate it, and give a brief explanation there. And then if there was corrective action issued against the person that's being accused, especially if it's a sexual harassment concern, a gender, one of those protected activities or characteristics that we were just summarizing, you want to be able to say, again, not detailed, but we did take appropriate action regarding this person. Or if it's severe enough and this person that's being accused is going to be terminated, of course, you want to inform that employee that the individual is being terminated.
What I like to say is when it's short of termination, something less than termination, but a corrective action, I usually phrase it generally.
Yes.
We've taken corrective action, and then I also put in some legally significant terms. I have the client say, that is our good faith. This corrective action and our good faith belief will resolve the problem and will prevent it from occurring again. If you have any other concerns in the future, right? If this does reoccur, please let us know immediately.
Oh,
right?
I'm going to take that. I'm going to use some of that language that you just said in my investigations. The good faith part is excellent.
A little better, because it probably didn't come out quite as smoothly as it should. But you get the idea, because the legal standard is for an employer who's now on notice, right, that an issue occurred, because, again, in my example, we took corrective action. So let's assume we substantiated something. Right? We don't necessarily have to fire the person. It depends, right, on severity and all sorts of things. But we do have to take action as employers that are reasonably designed to stop that conduct from reoccurring. That's our burden. Sometimes that means we have to fire the person, right, or else we're not confident that the conduct will stop. But sometimes something shy of that is perfectly acceptable. We don't have to be right? Again, right, Monday morning quarterbacking.
Exactly.
Someone can criticize us for not terminating, maybe doing a last chance agreement, for instance, instead of termination. But the courts will say, as long as we took that corrective action in good faith and had a reasonable belief, right, that that action was actually going to stop the conduct from reoccurring, we're okay. So I actually like to say it. Sometimes we, zhuzh it up a little bit to make it a little less legally and a little more, employee friendly. But I actually like to communicate that to the person that made the complaint, and then also encourage them to come back to us if something happens again. And then I also, you probably do this too, but also add in a non-retaliation statement, which is you will not be retaliated against in any way. Sometimes we zhuzh that up too, to say nothing bad will happen to you. Right? That's another way to say it without saying retaliation. Nothing bad will happen to you here because you came to HR with this complaint. If you believe something bad is happening to you because you came to us with this complaint, please let us know right away.
Now, you just mentioned nothing bad will happen to you, and that caused me to think about witness interviews, where witnesses, even if they're not the complaining party or the person being accused, that they're very nervous and they think that they've done something wrong, even though HR or an email introducing you to the investigation says this is nothing to do with you. You're merely a witness, and I want to speak with you.
Absolutely. Okay, let's talk about witness interviews.
Yes.
That's probably what everyone wants to hear about.
Absolutely.
Okay, so before we get into the interview, let's just assume we've done the pre-planning, right? We've talked to the complainant and the accused, and from their information, we now know all the people we need to talk to, right? Who is likely to have relevant information. So we have our list, we've scheduled interviews, right? And now Jane Doe walks in the door.
Yes.
Mary, do you do those interviews by yourself, or do you think there should always be two people from the employer's side?
Yeah, that is a great question, and my answer has evolved over the years. So I had always conducted interviews with two people in the room, and then with the witness. So there would be three people, one to take notes or one just to purely be a witness, even though both of us are taking notes, so that if there was a dispute on what the witness said, that I would have someone that was taking notes and is an additional ear to hear what is being said. Okay. I have switch that up a bit.
Really?
And it's been for a while, because I do feel like one person, whether you're an attorney or you're HR doing it, is very intimidating to the witness. They just want to go in, do their job. They don't want to deal with HR and take away from, let alone a lawyer. Right. So whether you're HR investigating or whether we are investigating, you may want to consider just interviewing the witness or the employee by yourself. And what you do with that is you of course, ask your questions. You typically have an outline of the areas that you want to ask, and then you take the notes yourself. Now, does that slow down the interview? Absolutely. but sometimes a slower cadence in the interview is a good thing, because when folks are nervous, they tend to talk very fast. They tend to forget something they want to say. And when you're asking the question and you're actually writing down their answer, it causes the process to slow down so that witnesses have time to listen and to think through what the questions are, and they're more inclined to give you the full information because they're like looking at you as you're writing it down. And then what I do to avoid the he said, she said situation in the interview room is that I say, look, thank you so much for talking with me today. I know it's last on your list. I really appreciate you being candid. The last thing or the worst thing that could happen today is that you walk out of this room and I have something wrong in my notes that you said. And so I would like this opportunity to make sure that I have your story correct, for you to look at my notes, and if it's wrong, revise it right here and now, and if it's correct, initial each page and then sign it so that I can make sure that your recollection is accurate. And I've had really good luck with that, and then you don't have to have an extra person in the room, and it's just the two of you having a conversation and trying to make it least intimidating as possible. So
I totally agree. In fact, I actually hand the witness my pen and my notes and say, go ahead and change whatever you like.
Yes.
Right? Because we need this to be accurate. And then oftentimes they'll think of something they forgot to tell me. It's not just that my notes were inaccurate. They'll just, because, I'm a pretty good note taker. So are you. But sometimes people will say, I forgot in this section when you ask me, is there anything else? Which is always what you end an interview with, right, Mary?
Yes.
Is there anything else? I forgot to mention this other time, right? So and then they handwrite that part.
And I also think it makes witnesses, and especially the person being accused or folks, if you're having a really hard time figuring out who's telling the truth, it makes folks more honest because they are signing something that says that this is truthful and accurate.
Yes.
So speaking of, trying to avoid the he said, she said situation, that has kind of evolved over the years too. It used to be, investigator will look at this or a judge will look at this and say, it was a he said, she said situation. It was a tie. How could they break that tie? They're correct of just having everyone go back in their corners and just start working. So that kind of has changed over the years. How have you viewed that? And then how do you try to break that tie when you do get, not a lot of witnesses, or you get a situation that's truly one person saying one thing and another person saying another?
Obviously, those are very tough situations. The first thing I do is I try to think about, is this really just a he said, she said? Is it really a tie, right? So I go back, I look at the documents again. Sometimes I go back and talk to the accused and the accuser and say, is there anyone else that could help verify when you said this or when you said that, right? And so I take another stab at it to try to avoid the pure he said, she said. I think it's legitimate to consider people's non-verbal cues during interviews too, by the way, right?
You're right.
People's, were they nervous? Did they make eye contact? How readily did they accept the invitation, right, to talk to me? All of those kinds of things, I think, can shift the burden. At the end of the day, shift the tie, so it's not really a tie.
Yep.
At the end of the day, our decisions don't have to be perfect. And when I tell clients that, it's like just a weight coming off, right? I'm not perfect. Are you perfect?
Far from it,
I didn't want to be presumptuous. Because I know I'm not.
I used to be, and then I grew up, and I'm like, I'm not perfect.
I'm still working towards it. As a colleague of ours likes to say, just because none of us are perfect does not mean we should cease striving for perfection.
Oh, I love that. Yes, absolutely.
But we're not, and courts know that, and everybody knows that. So if we do call it one way or the other, and at the end of the day, have full-blown litigation and trial, it turns out, oh my, actually the result of my investigation was wrong, we're still not liable as long as our investigation was timely, circling back to what we mentioned at the beginning, right? Thorough, and our conclusions were based on objective evidence. And by objective, I mean a document, an interview statement, et cetera. So let's take that pressure off of ourselves, because sometimes we do, well, every time, the investigation does have to come to some sort of conclusion. And when it looks like it's a tie, step one is to go back and make sure, right, that it's actually a tie. Bounce it off of someone else in your office, right? Go over all the evidence with them. Maybe they will pick up on something that you didn't, right? Maybe they'll come up with another question. You need to ask another witness to talk to, another document to ask for, right? Maybe we dig deeper in phone records, whatever it is. But you're right, Mary. Sometimes, even after that step one, we're still left with a tie. And I think that before a few years ago, particularly before the Me Too movement, I think ties went to the accused. Right? Do you think that's true?
I do.
If we couldn't substantiate, right? If we couldn't clearly say, yes, the accuser is correct, we'd say, well, if we can't clearly prove it, then we can't do anything on this other side. But now I think what's happened in light of the Me Too movement is we say, why does a tie go to the accused? Why doesn't the tie go to the accuser? And I have seen a shift in when we have no objective basis, right, to break a tie, who are we going to be left believing? We'll believe the accuser instead of the accused. Have you seen that trend as well?
Yeah, and that's where credibility becomes such a key regarding witnesses. Who has the motivation to lie? Why would the person bring this complaint up? And in the day of technology, lots of folks want to short circuit the investigation and just have a phone call, because there's seldom are employees working in the same location. And so I would urge against that, because body language, facial cues are so important. And so even in the world of COVID, sometimes person-to-person meetings are not that great if you have to wear a face mask.
Right.
Because we all know that our expressions and how we're talking is not always in our eyes, that we need to see the rest of our face in order to do an assessment on credibility and how they're acting. And so sometimes a Zoom or a team, a video chat when we're in the midst of COVID is far more appropriate than an in-person if we have to wear a mask, or for sure a telephone call or an email. We never, if we can avoid it, try to investigate via email. You miss so much, right? With tone, and they're able to, prep their answer instead of getting true, authentic answers.
And some folks, their first instinct is to go for the email, because then it's all documented. My questions are here, the answers are there. There is no he said, she said. But I totally agree with you. That is absolutely my last choice, right, in terms of how to get in touch with someone and interview them. And whether we fly around the country to talk to people in person might depend on the importance of the investigation and the severity of the allegations, right? Not everything may justify that, but if it is important, if it's a high-stakes issue, for me, in person is the way to do it. It also helps build rapport. We can sit far enough away from each other that we can maintain a level of safety, right, Mary? Because we're like, what, about 80 feet apart right now? So we could do this without masks on, right, and still feel like we're safe and following our rules here. All right, so one last, we've been talking a while. I have a feeling we could talk about this all day.
Oh, we can. We're just getting started, right?
We are just getting started. But I don't want to let you go without asking one of the other top questions we always get from clients when it comes to investigations, whether we're doing it or whether they're doing it.
Okay.
And that is confidentiality. Because in my experience, 80 to 100% of witnesses, that's the first question when they walk in the door. Right? Can you keep this confidential? Will you tell anyone else what I'm going to tell you? And of course, we want people to come to us and be truthful, right? And tell us everything on their mind. What do you tell witnesses in those situations?
Right, because we want to maintain the integrity of the investigation. We want people to tell us the truth, but we can never maintain complete confidentiality because sometimes this will be out of our control. We don't know if there will be an outside review where our documents will be reviewed by an outside source, whether it's the judge or the investigator or an attorney. And so in that instance, we can't say, oh yeah, whatever you say is going to be in a vault and I'm going to keep it forevermore. It is confidential. When I say no, we can't keep it confidential, that seems to scare folks. And they tend to go, oh, I don't know if I can do this. So how I approach it instead is say, I understand your concern. When I'm doing this investigation, especially if it's to the person who is bringing the complaint, say, as much as we can keep your name out of it, and sometimes you really can, depending on what the fact pattern is, what the complaint is, you can.
Absolutely.
Another piece of investigation that we probably don't have time for is investigating anonymous complaints because HR often says, oh, we can't do anything with it. Yes, you can, and you need to.
Oftentimes you can.
But just trying to assure them that you have no desire to make this more complicated than it has to be, but that when you're doing a report or anything, to as much as names can be left out, that you will, and that if and when there has to be a disclosure, that you're doing it just purely to get to the bottom of the complaint, but that you certainly aren't going to tell witnesses, for example, oh, well, Joe said this, so what did you say about that? And so it's a hard question to answer, but generally when you say, yes, we will keep it as confidential as possible. That usually calms them. Is that how you approach it as well?
I love that you answered it that way because we've actually never talked about this in life or even getting ready for this podcast, and that's exactly the way I handle it too. I will often say something like, I understand your concern. If I were in your seat, I would share the same concern. I will not share either your name or the information you share with me unless I need to conduct a thorough investigation, but we will not gossip about it. We will not share it with people who do not need to know, right? But I can't promise that nothing you say here won't be shared because this investigation is really important to the organization. And then I usually try to say something as to why, right? Like why, to give them some sort of, I don't know, maybe it's mom guilt or something I'm putting on them, but you don't want to screw up this investigation by not being completely forthcoming with me, right? Because here are all the reasons it's important. So a little guilt on top, never hurt anyone, but yeah, you can't promise, you just can't promise confidentiality. The hardest one is the one you mentioned, which is the complainant themselves. Oftentimes, they'll come and tell you an issue. It's usually not you or me at that point, right? It's a supervisor or an HR professional, and then say, but I don't want you to tell anyone. They literally just wanted it, that cathartic, they want someone to know, but don't want to be responsible, let's face it, for the fallout, right, of what might occur because they did that. How should our HR clients respond to the complainant that comes into their office? Let's just assume it's a serious complaint, right? Not someone taking someone else's lunch out of the break room fridge, for instance. Something that rises to a level of potential legal liability and then says, but I don't want you to tell anyone. How do your folks respond to that? How would you like them to respond to that?
Yes, because oftentimes that's where HR or managers trip up. Right? Because we all want to have a really good rapport with our employees, and we all work in hopefully an environment that is friendly and open door, and we want to hear these complaints, and we want our employees to trust us when we're in a leadership role. And sometimes employees take that to a point where they don't realize what they're saying to their leader or HR is really as if they're talking to the CEO, to the company. And so when you receive a complaint, and when we're talking about something serious, like one of those protected characteristics or activities, we can never say, okay, it stops with me, let me know how it goes, and then just let it stop. We have to investigate. And so what I typically would like our leaders, our HR to say is essentially pretty much what you said regarding our last question that we had is, this is really important. I don't want this to continue to, to percolate and to happen. And I do have an obligation to bring it to HR, or HR, if HR is hearing it, I do have an obligation to look into this. Yes. I promise you we'll be discreet as possible, we'll be as confidential as possible, but this is something that we really need to look into. And, sometimes employees are still very upset by that, but we do have to move forward, and that's where you just increase communication with the person who is making the complaint to try to have him or her be as comfortable as possible while still meeting that obligation that you do have to look into it.
Well, I really honestly feel like we could talk about this for hours and hours, but our time is up. So thank you so much for joining me today. This was so fun.
Thank you for having me. I really appreciate it. It was fun. Like I said, I love investigations, so I'm sure this is the highlight of my day.
I hope not. Bye, Mary.
All right. Bye, Beck.